We are live.
Hi guys.
Hello, welcome to the podcast. I'm John.
And I'm Hayley.
This is the Speed Mooting Partners in Crime podcast.
Coming to you very late on a Thursday evening, but for you guys listening, this will be Friday or beyond.
Yep.
So I guess you didn't need to know that we were coming to you very late from a Thursday evening, but
it's always helpful to know. I mean, we've had just a jam-packed week. It's been absolutely crazy. And then today has been manic because I was in Northampton. Should have been a quick hearing. Wasn't. I'll say no more than that.
It's still too painful to talk about.
It wasn't a quick hearing. Anyway, long and short, so I got home literally at 7 o'clock, wolfed down a pizza, and then we posted a public speaking course.
You certainly did.
So yeah,
we were getting a bit nervous at one point because the motorways were doing what they do.
Yeah.
So we were making contingency plans at one point, like, okay, John, you're going to have to pull over and hotspot and join the course from your car, and yeah, it was.
Thankfully, we didn't need to.
Like the skin of our teeth. We made it.
Yeah.
I think it was a really good course, wasn't it?
That was brilliant. That was amazing. So for those who don't know, we've just ran a course in conjunction with Liverpool Speakers Club. So Hayley was sort of comparing. Myself and David, both from Liverpool Speakers Club, delivered a talk all about public speaking. Mm-hmm. So we spoke about building confidence, building rapport, and speaking persuasively. So good broad range of topics. And then we opened it up to a Q&A. So, And
we got lots of great questions, some of which are going to be featured on tonight's podcast.
Yeah.
Because we didn't get to them all. There's only so much you can do in an hour's public speaking course.
I know, who'd have thought it?
Who'd have thought it?
Yeah. It's funny, like, because we were talking, weren't we, about, how important the Speakers Club is. And David said, was it important for me? And I said, absolutely, because... you finish the bar course and that's it. Unless you've got pupillage, you're not doing any advocacy, any public speaking. So this came up. Funny enough, a contestant on Countdown said they were in the Speakers Club. My mum went, "What's that?" Googled it, showed me, and we went to the next meeting. And so I went. I was like, "Oh, this is brilliant. This is the chance to come and do some public speaking." And it's amazing how much I picked up just from joining the Speakers Club.
Yeah.
So really interested, and hopefully people have learned a lot from our course tonight anyway.
Yeah, definitely. And it's interesting, speaking of the Speakers Club, so it's obviously very, very, very useful for lawyers and aspiring lawyers, and there is a good chunk of lawyers in not only our Liverpool Speakers Club but in the wider association of Speakers Clubs, because there's a Speakers Club pretty much in every city in the country. And in Scotland, yeah. But there's also just a huge variety of people that don't come from a legal background.
No.
So it's just a great way to meet a group of loads of different people who all want to be more confident or just enjoy public speaking. So it's always a good mix, isn't it?
And it's a good mix of people from all walks of life and all ages. So, you just...
Yeah.
There's nowhere else, I think, where you mix with such a broad range of people. It's brilliant.
I agree. So if nothing else, I mean, in Liverpool Speakers Club, we do socials and stuff as well, don't we? Yeah. So we do pub quizzes, we go out for food and all variety of different things. So gives you a little friendship circle as well, doesn't it? As well definitely. As building up your public speaking skills. So definitely. If you're listening to this and think, oh, I really want to go along, I don't want to go by myself, take your mum, take your brother, take your boyfriend, take your friends. Anyone can go to a speakers club. And you don't have to perform when you're there as well. People do just go just because they enjoy watching public speaking and mixing with people. So drag someone along with you if you don't want to go by yourself. That's my advice.
Yeah, definitely. So that was that. I think we need to introduce the episode.
Let's go.
So we're on episode 62. So last week it was a Formula 1 driver, wasn't it? So the first one we've done for about 6 episodes where there was a number. 62, there's no number, unfortunately.
Okay.
There is a 63. I understand we've got a very young fan who's very excited for episode 63.
I am not looking forward to this. She called me out because apparently I forgot who it even was, but the last Formula 1 named episode was apparently super obvious, and she can't believe I didn't get it. And she's going to be listening out to the next one, which apparently I should also know. So
okay, I'll give you some good hints next
the
week.
pressure's on,
The pressure's on. Hopefully you'll get that one anyway. Hopefully you'll get it. But no, 62, there's no number. So I was looking, I was thinking about looking at the 62nd Grand Prix, but the chances are it was probably Sterling Moss again who won that race. Seemed to be winning all the races in that sort of time period. Either him or Fangio. So I thought, well, let's have a little Google. Were there any wrestlers born in 1962? And there was.
Oh.
Okay, so there was a particular wrestler. So, first clue, he was born in 1962. Second clue, he held a streak at WrestleMania where he was undefeated in 21 matches. Unfortunately, he lost the streak at WrestleMania 30. That was probably the most shocking thing ever. And you think about it, that's built up over 24 years he'd been in the business at that point. So for 24 years, it's just a foregone conclusion. This guy always wins at WrestleMania. And then when he didn't, the arena went silent. And I remember watching on TV, wow. There'll never be a surprise like that again.
Wow.
Yeah, literally. I say wow, I think I was actually speechless. Because you think about it, because, you watch, people accept that, pro wrestling scripted. So, you can script it whatever way you want. And then when the guy that's expected to win all the time and, has done for 24 years, suddenly loses, imagine that.
Yeah.
So second clue, he had a 21 win streak at WrestleMania, which he lost to Brock Lesnar.
I thought John Cena just had the record by winning 18.
We're talking two different things, yeah.
Oh.
We're talking, they're championships. WrestleMania,
right.
This is just so WrestleMania is an event that comes once a year.
Okay.
It's their flagship event, like our national speed mooting competition.
Right.
So that comes once a year. So it's only one time a year, and he fights at it. And every year when WrestleMania came around, this guy won.
Okay.
Okay. He's a dead man. Okay. He's and his brother in wrestling was Kane.
It's Kane.
It's Kane. That's gotta be Kane.
Is it? Does he?
You've got to throw that clip in.
I will. Let's hope it doesn't get copyrighted out.
That's gotta be Kane. That's gotta be Kane.
Come on, Paul. You know what you're doing.
Does he have the theme tune? Dum.
He does indeed.
Oh God, what's his name?
Okay. Think about profession. Go on.
Stone Cold Steve Austin. No?
No, his theme was glass shattering.
Oh, you see, because I thought Stone Cold, because he's dead.
No. So, to give you another hint, so his name is also an occupation of someone that deals with dead people.
The Undertaker! Thank God for that. The pressure was on.
In comes Teddy Long. You're going one-on-one with the Undertaker.
So funny. You probably haven't seen this because you were on the road late last night and then you've been in court all day. One of our very loyal listeners sent us a clip on Instagram last night.
Yeah.
And it's a podcast clip. It was Stephen Fry was the guest, and I think it was Ryan or Rylan, the guy doing the podcast. And Stephen Fry was talking about his partner, who was 10, 20 years younger than him, and he's like, I can't imitate Stephen Fry, I won't even try.
Yeah.
But he's like, it's really interesting, the things he's got me into and the things that he likes that I think are so bizarre, but now I'm becoming a fan. I'm paraphrasing a lot. I'll show you the clip after this. And he goes, for example, he's got this weird obsession with WWE. He loves WWE. And then he starts talking about and doing the quotes from some of the things that he watches. And it's just so similar, because if I went on a podcast and was talking about you, that's probably what I would be saying.
That's funny, 18 months ago you probably couldn't name anyone. Now
no.
You know the quotes.
I know.
Okay, finish this one, Hayley. L.A. Knight.
Yeah. Oh God, is it sad or is it cute? You tell us.
You got to admit, when we went to see it live, and you got to admit that was a fun night, wasn't it?
I tell you what, it was. I liked the wrestlers coming out, because it was like a concert, the actual like fighting of it, I was a bit, I don't know if bored's the right word, but I was like, okay. It wasn't my thing, the fighting of it. But it was so entertaining, it was. I give you that. And the music, and when everyone comes out, and they come out for about 10 minutes, don't they? And they fight for about 2 minutes.
That's a fairly newish thing, that, over the past couple of years. I mean, entrances were always a big thing, but, you know, they'd be done quickly, but now they just go on.
That was my favourite bit, though. That was the best bit.
It is good. That's what gets... And this whole thing of the crowd singing along, like Randy Orton comes out, everyone sings every word to his theme tune. That 20 years ago, that wouldn't have happened. You know? Well, not 5 years ago, it didn't happen.
Yeah,
it just didn't happen at all. And now, when the music stops, the crowd still carry on singing.
Yeah, brilliant.
But anyway, it's not a WWE podcast, so
we're delirious because it's been such a long day.
Yeah, you wouldn't think I've literally been on the go since whatever time this morning, but still
all hyper.
Yeah. But
okay,
anyway,
let's move on.
Welcome to episode 62. The Undertaker special.
Welcome.
So, Hayley, we have just had the public speaking session. I understand there were some questions.
There were some questions, and the majority of them we did get to. So, I will edit that video and it will go on our YouTube channel at some point. I'm going to commit to it in the next month.
Okay.
I do have a backlog. You know, I've still got to spend the day with us at the National Speed Mooting competition to put together the vlog of that day.
I tell you what though, it's a good position to be in where we've got too many videos. Like, you think about when you start, you're like, oh, I need to put some content on this.
Yeah.
Now we've got too many videos to edit.
Yeah, we've got too many videos to edit. But yeah, I'm going to commit and say within the next month, the video of the recording of the public speaking course will be live. So keep an eye out for that for the majority of the questions. There were a handful we didn't get to, so we will answer them now. For public speaking, is there a usefulness to signposting at the start and summarising at the end? So I think this is talking about structure.
So it's talking a bit about structure. So I think what that question alludes to is a structure of intro, main body, conclusion, which is basically tell people what you're going to talk about, tell them, and then tell them what you've just told them, which is the perfect structure, I think. It's a good structure, that nice and basic, nice and straightforward. It's a classic structure, and it works well every time. Very good for legal advocacy, actually. So say you're doing some sort of, mooting, for example, it's quite often the structure you would use there. So 100% it's a very common structure and it works well. So there's nothing wrong with that at all.
Very closely related, and in fact you might say there's nothing to add to this question, but what is the recommended structure for a mooting argument?
See my answer to the previous question.
Yeah, I suspected as much.
That's exactly. So you've obviously got your skeleton arguments. If you take part in our competitions, cheap plug, we draft the skeleton arguments for you. But in traditional competitions, you'll do it yourself. So skeleton arguments take on different formats. People have different ideas for them. But as your general rule, your intro. So what's the background to the case? What are you asking for? Main body. That's where you work on your points. And of course, you'll sort of you'll have those as you go, and then a bit of a conclusion. So we're asking for what have you. So yeah, and that's the format that your submissions will follow. So introduction. So citation at the start. May it please the court. I appear on behalf of whichever party you appear on behalf of. Bit of an introduction. Here's what I'm asking for. These are the points that I'm going to be making. Of course, within that introduction, ask if you can dispense with formal citations. And then move on and follow the flow of your skeleton arguments, as you say, back your points up with authority as you're moving through. And then as you get towards your conclusion, just remind them what your key points are. And and in the circumstances, I invite the court to allow the appeal or dismiss the appeal, unless I can assist any further.
Boom. So we talked a lot in the speaking course about adapting your style to different audiences.
Yeah.
And this was a very specific question on that topic. In civil litigation, do you have any specific tips for opposing or trying to persuade a litigant in person?
So, right, I see. So when you're up against the litigant in person.
Yes.
Yeah, I mean, the reality is your job doesn't really, if you're against them, your job doesn't change. I think be as helpful as you possibly can, because, you think about it, if you were speaking to your, oppo beforehand, afterwards, you talk about, we can agree this, what's your view on this, what you're doing here. So, you can still be helpful to them and, point them in the right direction of any authorities, what have you. So, it's going to help the proceedings anyway. You're not pulling the wool over your opponent's eyes or anything like that. So be as helpful as you can to them.
Yeah.
And then when it comes to your submissions, your job is the same. You're doing exactly the same. What I would say is, maybe things that would be taken for granted in legal arguments. When you've got a legally qualified opponent and a judge. You might need to just explain certain things a little bit more in detail, break it down, avoid some jargon or explain the jargon. So just break your submissions down a little bit in that regard. But, at the end of the day, it doesn't matter whether your opponent is self-represented or legally represented. Your job is to do the best for your client. So, don't get away from that fact.
No, definitely not. I would agree. And I think my thoughts in reading that question, you think you've pretty much just answered it, but I was thinking, stay respectful, treat them with respect just as much as you would with a qualified opponent, as you say, John.
Yeah.
It'd be, very easy to think you can just talk in jargon when they don't understand, look your nose and at them or think, I can take advantage of them here, but would never be the right approach. And I think it probably would be quite harmful to you as well, because the judge would know you're doing that and know that this litigant person probably doesn't understand what you're saying. And human nature, I think, is, to root for the underdog a little bit. So if the judge can see, you're not treating this person with respect, it's probably going to turn them against you. Yeah. And it's very similar, isn't it, to in the criminal law? If you treated your witnesses like that, or you treated the defendant like that, if you're prosecuting, the jury are going to be like, why are they talking to him like this? Why are they treating him like this? And it turns them against you. So litigants in person, just as John says, help them as much as you can. Obviously never losing sight of that you are on opposing sides, but just how you would treat a qualified opponent, a litigant in person should be treated exactly the same.
Definitely. This video is brought to you by Speed Mooting. We are an organisation that help aspiring and junior lawyers. We run online and in-person advocacy and mooting competitions. We do online advocacy and public speaking training, and we run lots of other events to assist people on their legal journey. To learn more, visit our website, speedmooting.com.
Okay, so that pretty much sums up the questions that we didn't get to. There was a lot, but I grouped them together because, for example, answering questions on the spot and dealing with judicial intervention, we always get so many questions about them, and the advice is pretty universal. So thank you so much to everyone that came and answered our questions. If you did attend the course and you've listened to this podcast and you think there's something that we just didn't quite answer for you, drop us an email, info@speedmooting.com, and we will get to it next week.
Yeah, absolutely.
Okay, moving on. So I was having a think today about some content for the podcast.
Yeah.
And something we haven't done for a little while is our Learning the Law segment.
Oh, we haven't, have we?
So for people just tuning in, or if you haven't listened to an episode where we had this segment before, this is basically where we take a piece of law, a piece of advocacy, anything of that nature, and we just explain it in very simple terms for you all. So I thought today you could talk to us, John, about a skeleton argument.
Oh, skeleton argument. Okay. So, number one, it's not an argument that's presented by a skeleton.
Oh.
Yeah, so it's not an argument that comes out of Halloween. No, so a skeleton argument is a written legal argument. And where they come up, principally when you're a student, you'll have them in a moot. So, once again, break this down. For anyone who doesn't know what a moot is, it's a mock appeal hearing. So, a hearing that replicates one that goes to the Court of Appeal, Supreme Court on a point of law. But you have them in practice as well, because quite often you'll have situations whereby there'll be legal argument on something. So, taking crime, for example, you might have an interim hearing prior to trial, and there's going to be an argument about bad character. Does somebody's previous convictions go in? And, you know, it might be quite a unique point of law, and therefore both sides want to draft written arguments beforehand. You might have arguments on whether a specific defence can go to a jury, for example, whatever it might be. And the purpose of the skeleton argument is you exchange them well in advance of the hearing, and it's so the other side know what you're arguing. I remember speaking to a non-lawyer about this, going, well, why are you telling the other side what you're arguing? It's like, well, you know, it's not as if you're catching them off guard or anything like that. It's the whole purpose is so they know what you're saying, you know what you're saying, and the hearing can run effectively. Because if you didn't have them, you go in, you just have an oral argument. Well, I'm going to refer to the case of Smith and Hughes from 1974. Judge says to the what do you say about that case? I don't know, I've not read it. So both sides know what their arguments are, and they can prepare adequately for each other's arguments, and therefore you can have a hearing that flows. Otherwise, it'd just be a German to Germans as everyone's reading each other's arguments, etc. So you put your skeleton arguments in beforehand. You're setting out what you say the law is and how the law applies to your fact and why it is that you want the court to make the decision that they should. Likewise, your opponent will do the same thing, and then that becomes sort of the baseline for your legal argument. So I was touching on this before when it came to mooting, but I didn't want to take the wind out of myself, so I'll speak about it in a bit more detail now. So skeleton argument, you know, have it follow a proper format. So page 1, you know, court case number at the top right hand corner, forgive me, top left hand corner, what court are you in? Then beneath that in the centre, who are the parties, and they kind of come vertically like that, and then you'll have a bit of a heading underneath in tramlines, skeleton arguments on behalf of the whatever. Some people go to town and say skeleton arguments on behalf of the defendant in relation to the argument on, you know, I just say skeleton arguments on behalf of. And then from there, you move on. So I like to have every section headed. So have a header saying introduction. You know, if there are, well, this is an argument in relation to, so just a basic introduction paragraph. If there are background facts that you say are relevant, throw them in underneath. Then this is just one potential structure. Everyone has different structures, so this is just a potential. What you say the law is, so if there's a specific statute, you know, that covers whatever it is that you're dealing with, you know, set that out there. And then go on and start developing your argument. And of course, you know, just as with mooting, you know, it's a skeleton argument, it's an argument on law. More often than not, there's going to be case law that's backing up what you're saying. So include the case law there. Mm-hmm. And just, you know, you don't need to go to town, but say why it is that you say the case is relevant. If there are any, you know, specific passages from the case that you say are important, so a specific line, a specific paragraph, include that in the skeleton argument as well. You know, and say which judge said it. So, you know, you might be saying from the case of I don't know, Brown and Smith,
White,
whatever. Yeah, Brown and White, yeah, nice and simple. From the case of Brown and White, Lord Justice Brown said whatever, and then, you know, include the quote there. So include what you say is relevant, but crucially bring it back and explain why it's relevant. And then you move on to your conclusion, tie it all together. And that forms the base of your submissions, and that's, you know, what you're effectively going to be working from rather. And of course, you know, you will have the opportunity to look at your opponent's skeleton arguments, hopefully before, well, you should do before the hearing. So any cases that they cite that they say is relevant that you may not have picked up on, you know, you can take a look through those, see whether you think they're relevant. It might be that your opponent cited it because it's not relevant. I've certainly been in that situation before. So they are absolutely crucial, and they help these hearings to flow very well. Yeah. So that's a skeleton argument. So I mean, I was trying to explain how the front page looks. If you Google skeleton arguments, I'm sure something will come up, so you'll see in context what I'm talking about there. But yeah, massively helpful. And that leads us on to what we're about to talk about now, because a while ago now, I had a very, very interesting case, and it involves skeleton arguments, so we had to draft them. This was a new area of law for me. I was fascinated by this case. I learned so much about this particular area. So So on that episode a while ago, I spoke all about legal argument in court. And it was fascinating, particularly for me, who's, obviously the founder of Speed Mooting. I like me mooting, I like me legal argument. So we're going to slot in right here, me talking about legal arguments.
Yep.
You might see me look different. I've no idea how I looked on that day. So right now, my hair's a bit longer, I've got a beard. Maybe I had the same at that time, maybe I didn't. I can't even remember what I wore that day. Was it a suit? Was it a tracksuit? Was it a t-shirt? I don't know.
Well, you'll have to tune in tomorrow and find out, won't you?
I'm going to tune into tomorrow's episode to find out how I look, so don't spoil it for me, Hayley.
I won't.
So at this point, in a second, you're going to see me now. So we often get questions, don't we, Hayley, asking about, the similarities between sort of, mock type advocacy and real advocacy. And I've got an interesting story to tell about, a case I was involved in quite a while ago.
Yeah.
And we were in the middle of the trial, or coming towards the end of the trial anyway, and we literally had a day of legal argument because there was an issue about whether or not a certain defence could be left to the jury. So we had a full day whereby the judge said, I'm not going to have the jury in. You asked me to serve a skeleton argument. The prosecutor had to serve a skeleton argument on his behalf as well. And we had a full day of legal arguments, and it was all about whether or not this particular defence could go to the jury. And I just thought I'd talk about my experience of that because it was really interesting. And it was literally like having a real life moot. So, this was... I'd never dealt with an offence like this, nothing even similar to it. So it was interesting. It was a whole new area of criminal law that I was exploring, and there's a lot of case law on this. And so, there was quite a lot that had to go into my skeleton argument. And the reason that the judge was asking for a skeleton argument at this point is because those that instructed me had served one earlier on in the case. I got this case as a return, but there was... Because this is such a litigious point, there was a new Court of Appeal judgment that came out. So the judge said, I want you to serve a skeleton argument that deals specifically with this new authority, which the judge felt went against my argument. And also, to really streamline the skeleton. I say streamline, it still came out at about 12 pages or something. But it was really interesting doing that, serving the skelly, serving all the authorities, the prosecutor doing the same, having to cross-reference, read them all. And so given that it was my application for this defence to go to the jury, I had to stand up and, begin. And I'm going through, following with a bit of a structure. And I knew I was going to get cut off at some point. And so I've gotten through a couple of paragraphs of the skeleton argument. I say a couple of paragraphs, I'm not reading verbatim, but, the guide and my submissions. And just goes, okay, well, that's interesting, Mr. Dove. And then from there... it then literally became a Q&A because it was just so much judicial intervention. And I must have spent about 90 minutes at this point just on judicial intervention, with the judge quizzing me and a lot backwards and forwards. And so the judge very much felt that this sort of recent Court of Appeal judgment went against me. And there were certain points in this that I was able to use to distinguish. So it's like I talk about in mooting, I was having to try and distinguish this authority, but also I was trying to bring it back to a previous Supreme Court judgment as well. So it was really interesting, and the judge will go, well, what about this quote here? And I'd say, well, grateful, Your Honour, may I have a minute just to read the paragraph Your Honour's referring to? Oh, yes, take your time, Mr. Dove. And I'd say, oh, well, this is actually cross-referencing to another judgment, may I just cross-reference? Yes, of course, Mr. Dove. The judge was massively fair with everyone in this trial. And
did you enjoy all that judicial intervention?
Loved it. Loved it. It put me on the back foot, you know what I mean? It was it was a really good challenge, but it was so much fun, and it literally was real life mooting.
Wow.
Yeah, it was really good. So it was just an interesting experience. And all the things that I talk about, when it comes to mooting, these were things that I was incorporating for real. So when I was, referring the judge to a case, let's say I'm going to quote from a specific line because there's something I think is particularly helpful, I would be taking the judge to that specific part, waiting for the judge to find it, reading the quote out. The judge would ask me about certain cases, and I'd say, well, that's, I'd be looking for ways to distinguish the case. And I was looking at the factual scenario, looking for ways that it can be distinguished, and trying to once again bring it back to this Supreme Court judgment. So it was an interesting challenge, and it was something that was quite fun. But I just thought would be something to talk about on the podcast.
And it's really interesting. It makes perfect sense, but it's not something I've ever thought about before, where every defence that a defendant wants to run can't go to a jury. It's got to be valid and like upheld in law.
Yeah.
So if they're trying to say like, I don't know, some sort of self-defence that like doesn't exist, it can't go to the jury because it's not.
Yeah, pretty much. Yeah.
And that's what would happen in real life, right there. If you were trying to say, well, actually, this is a legal defence, then you have to have that argument.
Yeah, so you're trying to argue something that's not a defence in law.
Maybe self-defence was a bad example, but
Yeah.
I don't know. What's a better example?
I mean, to put it into context, this was a protest case. So, as I say, first time I've ever dealt with a protest case. And in effect, the defence that was trying to be run was this, which is, there's a series of new statutes that came out 2022, 2023 that effectively made new criminal offences or the codified previous common law offences. And the defence that was being put forward in this particular case was that by protesting, the defendants were exercising their Article 10 and Article 11 rights.
Yeah.
So Article 10 is the right to freedom of expression. Article 11 is the right to freedom of association. Bring the two together, and that's effectively where your right to protest comes from. So within this particular new statutory offence, there's a defence of a reasonable excuse.
Mm-hmm.
So what the defendants were trying to say is, well, look, we're seeking to rely upon our reasonable excuse defence, and in doing so, we're exercising our Article 10 and 11 rights. And then there's a series of there's cases that come from the European Court of Human Rights, and then a series of sort of Supreme Court and Court of Appeal judgments. And what we were trying to say is that when a defendant is relying upon the Article 10 and Article 11 rights, it's then for the prosecution to prove that any infringement of those rights, and the infringement in this case is prosecuting them for this offence and the subsequent conviction, that would be proportionate with their Article 10 and 11 rights. So in effect, prosecuting the individual for this offence is proportionate to the Article 10 and 11 rights. And our argument is that we were trying to say that the proportionality question is a question that should be determined by the jury rather than the judge.
Wow.
Okay. Now, if you're defending in those cases, the key judgment that you're seeking to rely upon is a case of Ziegler. So I think it's a 2021 judgment or 2023, if I remember right. It's obviously a while ago that I dealt with this particular case. So what you'd be seeking to say is that, well, Ziegler was an example of the court saying, well, look, the court needs to strike that appropriate balance.
Mm-hmm.
Now, there's other cases out there that suggest that, well, if the offence itself, so once the ingredients of the offence are made out, that strikes the appropriate balance.
Yeah.
So therefore, there's no need to go on and consider proportionality as a separate question.
Because it would have been considered when the offence was being drafted and cemented in statute.
Yeah.
Gotta say, I'm with you, Judge, on that one, John. Go on.
No, go on.
I was just gonna say, in the end, I think I know the answer to this, but we'll say it for completeness. So in the scenario where you're being instructed by a defendant to put forward a defence that isn't valid in law and there's no argument to be had, so like this example, there was an argument to be had, do you, as a barrister, have to withdraw? You can't present that case to the court, can you?
Well, yeah, I think if you know that something is absolutely not arguable at all, there's no merit in something, then you shouldn't be, as part of your code of conduct, you can't be presenting something that you know to be wrong in law.
Yeah. So you'd have to advise the defenders of that and say, this isn't a defence, so we need to plead guilty. And if they absolutely refuse, you say, well, I can't. I think you'd have to. I think if you were being asked to present something that you know to be wrong in law, then you've got to withdraw. Yeah. You'd be in breach of your ethics. I imagine that never happens, but if it did happen, that's what you would do.
Yeah, I think so. But with this, this is something where, there's a lot of case law and there's a lot of grey area.
Yeah.
And so, there are cases that can be argued. There certainly is a point that can be argued. And certainly, with the Ziegler judgment, it leaves the door open a little bit. On these sorts of cases. So that's why there was an arguable case there.
Wow.
Yeah.
There we go. John Dove doing a real life moot.
I know. It was interesting. I really enjoyed it.
I have to say, I've seen John do a few pieces of advocacy, haven't I? I've been to court with you a few times now. And it does blow my mind every time about how much it really is like what he teaches people.
Yeah.
And I know that's a crazy concept because he's teaching in advocacy club and through the competitions and things. Obviously, we are teaching people to do what needs to be done in real life.
Yeah.
But it's still a very weird thing to see John in court. May it please the court, and unless I can assist any further. It's like, it's so bizarre seeing it, but it really is exactly like what you're teaching people. It
is, yeah. I always remember that one of the most bizarre things was referring to judges in the third person. So, in the Crown Court, you never call the judge you. It's always Your Honour.
Yeah.
As Your Honour seeing this, obviously it's just second nature to you now, but when you first start, it's so bizarre.
Yeah.
Yeah.
Wow.
Yeah, interesting. But yeah, no, just thought that was something interesting to talk about, the moot king in a real life moot.
Yeah. So, good to know everyone out there that's taking part in mooting. You never know. Those skills do come in handy. Yeah. And it's good to know as well in real life you actually enjoyed the judicial intervention, because that's the point that everyone's scared of in competitions, isn't it?
Yeah. It's good as well, I think, because it gives you some sort of guidance, because, you can sit there and you have all these submissions, but if the judge had only bothered about, a certain aspect of it, they might be with you on everything else.
Mm-hmm.
Then it gives you some sort of guidance and you know where the judge's concerns are. And as I say, I don't say these things just for the sake of it. I say them because they're genuine. Think about where the weaknesses in your case are. Think about where the strengths in your opponent's case lie.
Yeah.
And with this one, I knew that this judge had read this recent Court of Appeal judgment and thought, there was certainly some weight in it. So I really had to think about, well, how can that judgment be distinguished?
Yeah.
How can I, seek to bring this more in line with the previous Supreme Court judgment? So I mean, it's going to be an interesting area of law. I imagine there's going to be a lot more sort of appellate case law to come out on this. So certainly not my area of expertise. I don't know how closely I'll be watching it, but
you probably will be a little bit now. You'll always have an interest in this because you done so much with it.
Yeah. I certainly spent a lot of time on that case.
There we go. Hope that was useful, everyone.
Hope that was helpful. So, back to John Dove from the 5th of June. So, I hope you enjoyed that little segment of me speaking. I can't even remember when that was now, but it was a long time ago.
It was a long time ago. I think you wanted to talk about it while it was really fresh in your mind.
Yeah.
But obviously, we didn't want to publish it right away because the case was ongoing. So it's... I mean, I don't think you'd identified the case in any way, shape or form. But it's always best to exercise caution, so we thought we'll hold it for a little while.
Yeah, definitely. So I hope you enjoyed that segment. So, I think that brings us towards the end of the episode anyway.
Mm-hmm.
Coming up this month, we've got debating at the Advocacy Club. We've got the first of our 3-part session on the criminal trial. So, members of the Advocacy Club get to deliver an opening speech this month.
Mm-hmm.
And we've got a handful of places left for our plea-in mitigation competition.
Yes.
So if you want to take part, sign up quickly, because I reckon by the time next week's episode comes out, the ship will have sailed.
I think you're right, John. I think you're right.
So that brings us to the end. I've enjoyed recording it, Hayley. Have you enjoyed recording it?
I've enjoyed recording it, John.
I hope you have all enjoyed listening. And if you are still listening at this point, I think it's got to be the Undertaker's finisher move that you comment below.
I was going to say skeleton, but okay.
Okay. Well, it's all kind of linked, isn't it?
Go on, what's his finisher move?
Well, he's got 3, and I'm trying to think which was good. This one might be a good one for the comment the last ride.
The last ride, okay.
The last ride.
And also take a moment, if you haven't already, to subscribe. If you're listening or watching on YouTube, subscribe to us on Spotify and give us a rating, please.
Yeah, takes a few seconds, helps us massively.
Yes.
So, that is the end. Cheerio.
Dum.
Done.